Expert testimony of Lawrence Cirillo, University of Maryland, University College. Capstone in Cybersecurity, Dr. Ruth Parker, September 8, 2018. Chris Soule, Robert Blackwell, Robert Jones, Chris Haas, Lawrence Cirillo. Bailiff. All rise. Department 5 of the Supreme Court of Australia is now in session. Judge Bullen presiding. Please be seated. Judge Bullen. Good morning, ladies and gentlemen. Calling the case of the people of Australia versus John Doe. Are both sides ready? District Attorney. Ready for the people, Your Honor. Public Defender. Ready for the defense, Your Honor. Each side provides their opening statements to the judge and presents their evidence to the judge. The District Attorney goes first and the Public Defender goes next. After the opening statements, witnesses are called to testify about what they know about the case. Judge Bullen. The prosecution may call its first witness. District Attorney. The people call Lawrence Cirillo the digital forensic examiner. Bailiff takes the witness to the stand. Clerk. Please stand. Raise your right hand. Do you promise that the testimony you shall give in the case before this court shall be the truth, the whole truth, and nothing but the truth to help you God? Lawrence Cirillo. I do. Clerk. Please state your first and last name. Lawrence Cirillo. Lawrence Cirillo. Clerk. You may be seated. Reporter. Please spell your last name for the record. Lawrence Cirillo. LaurenCirillo. District Attorney. What are the legal challenges associated with cyber incidents involving foreign countries? How do internal laws affect e-discovery? Legal challenges associated with cyber incidents consist among different nations. Technology has a strong impact in society and will continue to create legal challenges within the digital forensics field. Many of today's activities are increasingly dependent on information systems, electronic devices, and data networks. In addition, new threats and vulnerabilities emerge which allow security risks to increase in numbers. Therefore, the need to protect information and other assets at various levels, field industries, companies, users, and countries is important. Legislation in several countries is requiring increase and improved security based on objective moral and ethical criteria. The EU is encouraging having a computer security incident response team. The United States Congress approves the Cybersecurity Act of 2015 to protect the country from cyber attacks by promoting the exchange of information between the private sector and the government about computer threats. In Latin America, a document was created to determine cybersecurity capacity in Latin America and the Caribbean. This document highlights the importance of responsible disclosure of information in public and private sector organizations. It also emphasizes the importance of legislative framework, investigations, processing of electronic evidence, and the training of judges and prosecutors in the field of cybersecurity. Also, the Asia-Pacific region considers legislation as a basic indicator of the security landscape. Several countries in this region launched new cybersecurity policies in order to adapt to new challenges and emerging issues. For example, Australia has implemented a cybersecurity strategy which provides for additional funds and has increased commitment from the private sector to engage with the country's cyber policy. Other countries like New Zealand have launched national cybersecurity strategies focusing on improving international cooperation and the ability to respond to cyber crime. Discovery can be viewed in a couple of ways. First, as a relatively strict set of requirements focusing on searching for content that may be relevant for use as evidence in trial or in pre-litigation activities. Viewed in this way, it can include any sort of document or other information that might be useful to prove a plaintiff or defendant's case in a civil action. Viewed more broadly, discovery can be considered the ability to search for content not only within the relatively strict confines of court-ordered discovery activities, but finding content that might be relevant in the context of any litigation-related activity, such as senior managers performing informal early case assessments or department managers searching for potential dampening content in their employees' communication. Thus, e-discovery is the extension of the well-established discovery process to any electronically stored information that an organization might possess, such as email messages, voicemails, presentations, word processing files, spreadsheets, tweets, Facebook posts, and or other relevant communication or information that might be useful in a legal action. E-discovery is a critical process that occurs early in civil litigation matters and involves the exchange of information between parties involved in a lawsuit or some other legal action. E-discovery has implications for a variety of activities, including the archival electronic information, the ability to search for relevant content, the ability to modify content deletion policies, how storage systems are managed, and how corporate policies are developed. The importance of e-discovery should not be underestimated. It is among the primary drivers for the deployment of archiving systems and has significant implications for how organizations retain, store, manage their electronic content. A failure to manage e-discovery properly can carry with serious ramifications. Moreover, the problem of e-discovery is expected to become more serious by the growing numbers of e-discovery requests. Australia is a nation that participates in e-discovery and uses strong e-discovery tools to search for electronically stored information, but there are some differences that need to be stated. The court systems work slightly different than other nations because it is common in Australia that juries are almost without exception are not permitted in civil actions. Litigation generally, and e-discovery particularly, are less aggressively pursued in Australia than in other nations. A smaller bench and bar prompts a greater sense of personal accountability when counsel fails to produce relevant evidence. Another distinction in Australia e-discovery practice is that they use different e-discovery tools than in other nations. Australia likes to use the locally developed Ringtail review platform and Adobe PDF as a production format. While competing products like Relativity are not unknown in Australia, they have achieved little market success compared to their dominance in the United States. PDF is a more efficient and cost-effective form than TIFF in injury. In addition, Australia's development of robust e-discovery processing tools, Prooffinder and Atella, were created in Sydney and have all seen market success and featured integration in the last few years. Australia's Supreme Court of Victoria, Practice Note No. 1 of 2007, strongly suggests that the parties to a legal action consider using technology to improve the efficiency of legal proceedings, including e-discovery tools. The Federal Court of Australia has developed e-discovery rules similar to those contained in the 2006 amendments to the FRCP. Moreover, the Australian Federal Court ruled in 2009 that all cases meeting minimum requirements must be managed only with digital content and not via paper-based means. District Attorney. What are the legal challenges of accessing and retrieving electronic evidence stored on foreign soil? Assuming cloud storage was used, what procedures were followed to access and retrieve digital evidences stored in the cloud? The growing use of online and cloud services in the community means electronic evidence is moving beyond the physical jurisdiction of Australian law enforcement agencies. In Australia, two key laws provide protection to consumers when using cloud services: the Privacy Act and the Australian Consumer Law. The Privacy Act addresses how personal information must be handled to ensure protection of information or opinion about an individual and that it cannot be linked from the data to the person. Australian consumer law protects consumers from false or misleading contracts and poor conduct from the providers. The Privacy Act can apply for Australian consumers, even if the cloud service provider is based overseas and other laws are stated in a contract. Before data can be forensically analyzed, it must be identified and preserved. Law enforcement agencies can access certain data without the need for a formal warrant. For example, cloud service providers are obligated to render reasonable assistance under Section 313 of the Telecommunication Act of 1997 for the purpose of enforcing criminal law and laws imposing penalties, assisting to enforce the criminal law of a foreign country, protecting the public revenue, and safeguarding national security. It is also possible for Australian law enforcement agencies to apply for a warrant under the Telecommunication Act of 1979 to intercept telecommunications in real time, which may allow access to data stored on a cloud server. District Attorney. Specific to the country that your team was assigned, how did the international laws and jurisdictions influence the processes and procedures followed during the forensic investigation? Portability and connectivity of computer systems create questions about jurisdiction. The legal system in one jurisdiction differs from another in the location of data and information. Digital forensics evidence must meet the formal requirements of the courts if it is to be admissible in a court of law in a particular jurisdiction. An act that may constitute a computer crime that is actionable in one country may be acceptable in another. For instance, in a landmark case, an Australian businessman was awarded the right to sue for defamation in Australia by the Australian High Court over an article published in the United States and posted on the internet. Digital evidence seizure is closely linked to the issue of privacy. Article 12 of the UN Declaration of Human Rights endorses the right of privacy of everyone. Therefore, people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Search warrant and search seizures of digital evidence is the first process that is most commonly disputed in court cases. During this initial process of the forensic investigation, the use of improper methodology or unlawful search and seizure can affect the admissibility of the evidence. The forensic investigator must therefore ensure that the privacy of a suspect is not infringed in any search. The legal procedure for searching and seizing computers with a warrant relates to the legal framework for other forensic investigations. In addition, the forensic investigator must not only identify and articulate a probable cause necessary to obtain a search warrant, but also recognize and limit the warrants for the search and seizure. In a criminal case of child pornography, Yahoo technicians retrieved all information from the defendant's email account after receiving a search warrant. A lower court ruled that the seizure of the emails by Yahoo was unlawful because of the absence of police presence during the search of the defendant's email account. However, a higher court reversed the lower court's decision. The higher court ruled that the search of the defendant's email without a police officer present, but with an issued search warrant, was reasonable, and therefore the defendant's privacy rights were not violated. Another example is when more than one warrant had to be sought during the forensic investigation process. Search warrant for evidence of online harassment was issued and given to the detective to search and seize the defendant's computer and related items. During the initial search, the computer lab examiner found some pornographic images of children. The search process was halted, and a second warrant sought to provide authority to search for evidence of child pornographic pictures. District Attorney. What conflicts arose between ethics and international laws during the forensic investigation? How did these conflicts affect the investigation? How were the conflicts mitigated and resolved? Digital forensics examiners all confront ethical dilemmas because they use privileged access to view data on computer systems, and because their services are almost always involved with sensitive matters. Examiners, at one time or another, will be exposed to trade secrets, threats to national security, information that private parties may reward for, and highly personal information, including diaries, notes, and personal photographs. Evidence found, overlooked, or determined not to exist by examiner may decide the outcome of a multi-million-dollar case, whether someone is imprisoned or set free, or a rich parent will be rewarded custody of a child. The relatively recent and rapid evolution of computers and information systems has resulted in unique capabilities to store, retrieve, and process information. New fields of expertise, such as ethical hacking and cloud forensics, have emerged, all of which have added to the huge demand for highly educated specialists in the discipline of digital forensics. Likewise, the capabilities made possible by the evolution of computers and information systems have given rise to a large amount of controversies regarding boundaries and obligations, intellectual property rights, privacy rights, diplomatic relations, military affairs, critical infrastructure, and the public welfare. Although some controversies can be anticipated and addressed by contract, the remainder are to be resolved in a court of law. But both civil and criminal law are having trouble keeping pace with technological and trends catalyzed by technological advances. For example, there is no wording in the Electronic Communication Privacy Act, nor its legislative history, that makes any reference to the Internet. And even where the law may seem certain, pursuing a judicial remedy is costly and burdensome. Consequently, organizations have adopted a code of professional ethics to provide examiners with the framework necessary to avoid or mitigate liabilities likely to require judicial remedies. In this regard, the Code of Ethics provides principles against which one's decision-making is measured. The Code of Ethics serves other important interests, including presenting an image of prestige and credibility for the organization and the profession, eliminating unfair competition, and fostering cooperation among professionals. Currently, education and training in the digital forensics discipline is focused primarily on technical understanding, which does not emphasize on the significant level and ethical challenges confronting the examiners. Also, much of the informal writing on the topics of ethics is limited to the examiner's duty to search for exculpatory evidence in addition to evidence that tends to support the theory of the case asserted by the party who engaged the examiner. Therefore, until ethical training is offered with technical training, cyber forensics examiners will remain ill-prepared to meet these legal and ethical challenges. District Attorney. What steps were taken to protect all countries and citizens during the international investigation? Describe any risks to the country, businesses, or citizens from your investigation. The United States and the rest of Five Eyes must take certain steps to protect all governments and their citizens. Whether related to malicious cyber activity, criminal conspiracy, or the intent to commit a crime, digital evidence can be delicate and highly sensitive. Cybersecurity professionals understand the value of this information and respect the fact that it can be easily compromised if not properly handled and protected. For this reason, it is critical to establish and follow strict guidelines and procedures for activities relating to computer forensic investigations. Cybercrime, tracking malicious online activity, has become crucial for protecting private citizens, as well as preserving online operations in public safety, national security, government, and law enforcement. Tracking digital activity allows investigators to connect cyber communications and digitally stored information to physical evidence of a criminal activity. Computer forensics also allows investigators to uncover premeditated criminal intent and may aid in the prevention of future cybercrimes. In addition, law enforcement agencies are becoming increasingly reliant on designated IT departments, which are staffed by seasoned cybersecurity experts who determine proper investigative protocols and develop rigorous training programs to ensure best practices are followed in a responsible manner. In addition to establishing strict procedures for forensic processes, cybersecurity divisions must also set forth rules of governance for all digital activity within an organization. This is essential to protecting the data infrastructure of a law enforcement agency as well as other organizations. Prior to conducting an investigation, the investigator must define the types of evidence sought, including specific platforms and data formats, and have a clear understanding of how to preserve pertinent data. The investigator must then determine the source integrity of such data before entering it into evidence. In order to effectively investigate potential evidence, procedures must be in place for retrieving, copying, and storing evidence within appropriate databases. Investigators typically examine data from designated archives using a variety of methods and approaches to analyzing information. These could include utilizing analysis software to search massive archives of data for specific keywords or file types, as well as procedures for retrieving files that have been recently deleted. Data tagged with times and dates are particularly useful to investigators, as suspicious files or programs that have been encrypted or intentionally hidden. Analyzing file names is also useful, as it can help determine when and where specific data was created, downloaded, or uploaded, and can help investigators connect files on storage devices to online data transfers, such as cloud-based storage, email, or other internet communication. This can also work in reverse order, as file names usually indicate the directory that houses them. Files located online or on other systems often point to a specific server and computer from which they were uploaded, providing investigators with clues as to where the system is located. Matching online file names to a directory on a specific hard drive is one way of verifying digital evidence. In addition to fully documenting information related to hardware and software specs, computer forensic investigators must keep an accurate record of all activity related to investigation, including all methods used for testing system functionality, retrieving, copying, and storing data, as well as all actions taken to acquire, examine, and access evidence. Not only does this demonstrate how the integrity of user data has been preserved, but also ensures proper policy and procedures have been adhered to all five parties. As the purpose of the entire process is to acquire data that can be presented as evidence in a court of law, the investigator's failure to accurately document his or her process could compromise the validity of the evidence and ultimately the case itself. Judge Blunt. The court is adjourned.